Hello everyone, this is Lahama Mazumdar from the School of Law and Justice, Adamas University, Kolkata. Today I will be speaking on the process of registration of trademark in India. So, as you are aware, a trademark is a pivotal branch of intellectual property, and there are different types of intellectual property such as patent, industrial property, trade secret, copyright, geographical indication, and trademark is certainly one of them. It is the unique identity of a product. A trademark could be a word, a symbol, sound, logo, a combination of color, or even an identified smell. The provision relating to trademark are provided within the Trademarks Act 1999. Trademarks can be utilized even without registering the mark for that matter. Without registration, if there is an issue of a deceptively similar trademark in the market, a passing of claim can be made. However, if you register a trademark, this can have a far-reaching benefit which can be inferred from the provisions of the Trademark Act 1999 itself. In comparison to patent, trademarks are not that expensive and neither are they time consuming. The limitation with trademark, however, is that they cannot protect the whole article. The protection is limited to the symbol or the logo of the product. According to the World Intellectual Property Organization, that is the WIPO, the definition of a trademark is a sign with the potential of distinguishing between the goods and the services of different enterprises. It could also be interpreted to have a brand value. A trademark can be acquired by an individual, a business organization, or any legal entity. In India, the provisions concerning the registration of trademark are governed by the Trademark Act of 1999, the Trademark Rule of 2002, and the Trademark Amendment Rule of 2017. Now the question over here is it even worth registering the trademark? What's the point of having a distinctive idea if anyone cannot utilize the same for his or her advantage? If you want to have a distinctive idea, you would want to have a right over it. That is what Locke said. If it is a particular labor or a skill that you have invested in, you need to have the fruits of your own labor to your name. So here, to be the king of your own business, you need to have a registration of a trademark. It is vital to register the trademark and protect it from any sort of misuse by a third party. Therefore, in order to protect it, you need to register it. Because once you register the trademark, you acquire the right to sue in case of an infringement. In case another person is trying to create a counterfeit good of the same nature as yours, and they are trying to pass off, they are trying to have a free ride over the goodwill that you have acquired in the market. Anyone who's claiming to be a trademark owner or who intends to use the trademark in the future can submit an application in writing to the relevant registrar by the established procedure. The application must be in the name of the good, the mark, the service, as well as the class of the good or the service that it belongs to. The applicant's name, the address, the amount of time the mark has been in use, that also all of that needs to be mentioned. Here the term person refers to a group of business, partnership, a corporation, a trust, a state government, or the federal government. According to Section 7 of the Trademark Act 1999 and Rule 20 of the Trademark Rule 2017, it has been provided that the registrar has the power to classify goods and services in accordance to the International Classification of Goods, that is the NICE classification, whereby they can essentially state which are the type of goods which can be registered under which class. The classification of goods and services have been defined under Rule 20 of the Trademark Rules 2017, whereby it is stated that classification of goods and services for the purpose of registration of trademark, the goods serviced shall be classified under the NICE classification as published by WIPO, the World Intellectual Property Organization. So, for example, a particular class could be defining with regard to only cosmetics, a particular class could be with regard to food and beverages. So, according to the NICE classification, there are different numbers, alphanumerical numbers for different classes under which you will register your particular trademark, depending upon the nature of the good that is there. Now, it essentially helps in trademark search, because you can actually see which particular in your particular class of goods whether a similar trademark appears or not. So it can be used for determining the nature of two trademarks, so to understand whether it is a competing mark or not. Now, once the trademark search is done and you find that there are no competing trademarks that are there, you can file an application for trademark. So under section 18, let me show section 18 to all of you. Just a second. So as you can see, section 18 of the Act outlines the process of registration of a trademark. In order to apply for registration, the applicant must meet the requirements as outlined in the Act. Subsection 1 states that any person claiming the trademark may submit an application in writing to the registrar in the appropriate way. A single registration application can be submitted for many classification of products or services. However, as stated in section 2 of the Act, various fees will be applicable to each kind of product or service. If the applicant or joint applicant desires to apply, they must do so within the geographical limitations of their primary place of business. If they do not conduct any business, the application must be lodged inside the geographical limits of the site for services. Section 18 essentially provides that an application has to be made under section 18. It will be filed with the trademark registry within the territorial limits of the principal place of business in India, and as per the registrar offices, for example in Mumbai or its branches located in Kolkata, Chennai, Ahmedabad or New Delhi, the registration can be made. Now there is a TMA form, so there is a draft regulation whereby an applicant may submit his application. In the application per se, there are certain requirements, there are re-registration requirements. The central government appoints a person to be known as the Controller General of Patents, Designs and Trademarks, who will be the Registrar of Trademark by stating it in the official gazette. The central government may designate additional officials if they believe they are appropriate for discharging, and the registrar may permit them to discharge under supervision and control of the registrar. Subsection 4 of the section 18 specifies that the registrar has the authority to accept, reject an application. Has the authority to accept, reject or make certain adjustment, revisions subject to the specific jurisdictions or limit. If the registrar refuses or imposes restrictions, He must explain why and what materials were utilized. The registrar has the authority to transfer or remove cases by a written request with justification. This has been covered under Section 6 of the Act on how to keep a registered trademark active. Except for the trust notice, all specified details, including those of registered trademarks, must be recorded at the main office. Each branch office is required to maintain a copy of the register. It permits the preservation of documents on diskettes, computers, or in any other electronic format. Now, when a particular trademark application is made, there is an examination of the particular trademark. The examination is essentially done by the trademark examiner. The trademark examiner essentially states whether a particular application could be accepted or not. So essentially the process is that there is an application phase under Section 18, there is withdrawal of acceptance under Section 19, there is advertisement, there is correction, there is advertisement, there is opposition, there is correction and amendment, and then finally a registration. Now, under Section 18 itself, the particular trademark owner has the right to, the trademark registry has the right to examine a particular application. So while examination, Rule 33 of the particular Rule 33 of the particular Rules Trademark Rule 2017 essentially provides with regard to examination of a trademark. So here the registrar can cause the application to be examined as per the provisions of the Act, whereas the search shall be conducted amongst the earlier trademarks registered and applied for registration. Yes. So the registrar shall cause for the application to be examined as per the provisions of the Act, wherein a search shall be conducted amongst the earlier trademarks registered or applied for registration, for the purpose of ascertaining whether there are on record in respect of the same good or services or similar goods or services any trademark identical with or deceptively similar to the trademark applied for. So there will be examination that will be conducted by the registry itself. So when the trademark registry examines the application, if there is a deceptively similar mark, then of course they will object the particular application and they will share their examination report with the particular trademark owner, the applicant, and the applicant has to reply to that particular exam report. So there is an exam report, right, and there is an entire reply that has to be filed. So now after the filing of the particular reply, what happens is in the next particular criteria, in the next particular stage, there is a process of withdrawal of acceptance. So where after the acceptance of an application for registration of a trademark, but before its registration, if the registrar is satisfied that the application has been accepted in error, or that in the circumstances of the case the trademark should not be registered or should be registered subject to conditions or limitations, or subject different to the conditions or limitations under which the application has been accepted, the registrar may, after hearing the applicant, if he so desires, withdraw the acceptance and proceed as if the application had not been accepted. So these are the processes of examination. So there is a formal examination and there is a substantive examination. Formal examination is just conducted upon the receipt of the application to see that all the details have been filled. And there is a substantive examination procedure as well, where the examiner decides that the application complies with the formal requirements or not. So a substantive examination will also take place. Substantive examination is where the examination is carried out by the examiner on the substance of the application. So whether the substance of the application will be checked, whether it can be registered or not, that will be checked. Now, there are certain grounds for refusal of registration as well. Now, these grounds of refusal will now be discussed. So when a particular applicant applies for a trademark and then it goes for examination, there are certain grounds under which the examiner, the trademark examiner, can reject the application. So a few of those grounds are mentioned under section 9 of the act, and the rest, there are also relative grounds of refusal of registration mentioned under section 11 of the act. So let's understand what is there under the absolute grounds for refusal of registration. Section 9 lays down, of the particular act lays down, that absolute ground for refusal of registration, any trademark that falls under one of these particular grounds could be refused registration. And what are these grounds? First is that the trademark does not have any distinctive character. Right. If the trademark does not have any distinctive character, then in that scenario, the trademark will be denied registration. So in the earlier particular video, we saw that a trademark requires the criteria of distinctiveness. There is an Abercrombie spectrum of distinctiveness. There is a criteria of a mark to be arbitrary or inventive, right, with regard to the product it is being used for. It could be suggestive, it could be descriptive, it could be generic. So generic and descriptive have the least amount of protection that is accorded. Generic marks do not get protection. Descriptive might, in case it acquires a secondary meaning. Right? We saw with regard to surnames, it can acquire protection if it acquires a secondary meaning. Second of all, another ground is that a trademark that only consists of marking or indications used in commerce to designate the kind, quality, amount, intended purpose. So these are descriptive marks basically. So then this kind of descriptive marks also suffer the problem of registration. Then trademarks which also comprise of markings or indications that have become usual in present language or established trade practice, genericide. If a particular mark becomes generic, it will suffer the issue of registration. Trademarks that deceive or confuse the public. So in case the particular examiner conducts a trademark search and finds similar marks, deceptively similar marks, finds that the application is purporting to a deceptively similar mark, as in a mark of that kind is already registered for the time being, which is a valid mark, and the application is purporting to a deceptively similar mark, and it would confuse the public as to the origin of the good, then in that scenario also the particular the particular examiner may refuse the particular registration. Trademarks that contain anything likely to offend the religious sensibilities of any class or section of the Indian people, that can also be refused registration. Trademark including scandalous or indecent material can be refused registration. Trademark, if it is forbidden under Emblems on Names Prevention of Improper Use Act 1950, it could be refused registration. Trademarks derived from the form of the item themselves can be refused registration. Marks consisting of markings on items whose shapes are required to achieve a technological outcome could be refused registration. Now, there are also relative grounds for refusal of registration. Section 11 of the Act provides for relative grounds for refusal of registration, whereby it states that a trademark cannot be registered if there is a likelihood of confusion due to its identity with an earlier brand or resemblance of product or services, or its likeness to an earlier trademark or similarity of goods. It also states that a trademark that is identical or similar to an earlier brand cannot be registered. Also, if or the extent that the previous trademark is well recognized in India, so if it is a well-known trademark, then in that scenario, even with regard to non-competing areas, non-competing products, it cannot be receiving any registration. Now, post the stage of examination, if in any case there is uh, no particular issue that is there, if the particular examination is cleared, like if a particular application is clearing the process of application, like and the process of examination as well, if those are cleared, then in that scenario, the particular application goes through the process of advertisement. So under section 20 of the Act, the particular application is advertised by the registrar, and here the particular advertisement is done, and through the advertisement what happens is there is a invitation of opposition. So if at any point of time uh, any particular person has an issue with regard to the trademark that one person is applying for, then at that point of time, the person who is having the objection could actually apply for the opposition. So now, what is the opposition phase? So as you can see, section 21 of the particular act essentially deals with the opposition. It addresses opposition to registration and could be connected to the trademark rules 2002. So under rule 42, it talks of opposition. It states that within 4 months from the date of publication of the trademark journal in which the application for registration of the trademark was advertised or re-advertised, a notice of opposition to the registration of a trademark under subsection 20, under subsection 1 of section 21 shall be filed. So within 4 months of publication, within 4 months of advertisement, the opposition has to be filed. Rule 43 essentially lays down the requirement of a notice of opposition. It states that a notice of opposition or an objection must include uh, how the particular application, like whether it is whether the new application is deceptively similar to the earlier existing trademark, right? So in case of the opposing party, so that ground has to be explained. Under rule 44, the counter statement, the filing of a counter statement has been mentioned. So once somebody files an opposition, the applicant has to file a counter statement under subsection 2 of section 21. That is within the 2 months of the applicant receiving a copy of the notice of opposition from the registrar. So first is there is an advertisement. After advertisement, there is a process of opposition starting. So if somebody opposes the application, that opposition has to be filed within 4 months. After the opposition, what happens is that the other party over here, the other party needs to file for the counter statement stating why they are not exactly infringing the other person's trademark, right? So that counter statement will again be sent to the opponent. Now here rule 45 talks of evidence in favor of opposition. Rule 46 talk about supporting document for application process, and rule 50 mentions about hearing and the decision. So essentially, after the process of filing of counter statement, supporting documents are filed within Rule 46. So it is stating that within 2 months of the applicant receiving the copies of affidavits in opposition or notice that the opposition's opponent does not wish to provide any evidence in opposition, the applicant must leave with the registrar any affidavit based evidence he wishes to present in support of his application and deliver the same to the opposite party. Rule 47 talks about the opponent's evidence in reply. The opponent may provide the registrar with evidence by affidavit in reply within 1 month of receiving copies of the applicant's affidavit from the applicant and shall give the copies of the same to the applicant along with any exhibits and shall notify the registrar in writing of such delivery. Finally, under Rule 50, the process of decision and hearing and decision has been provided, where it has been stated that the hearing must take place within 1 month from the initial notice date. A hearing between the two parties may be requested by the registrar. He will then make a decision based on the arguments made by the two sides. If he grants the applicant's request, the trademark will be registered. The trademark will be taken down from the journal and the registration request shall be denied. In case the opposition does not happen, in case the trademark is not opposed to, or in case the person applying wins the entire process, then in that situation section 25 will come into action, whereby the registration shall happen. So essentially section 25 states that the procedure and registration of a trademark, the registrar, after receiving the application form, the trademark owner, in the required format within the allotted time frame and with the required payment of cost, may register a trademark for a term of 10 years, and it shall also be renewed. It could also be eligible for renewal of 10 years after the initial period of registration is expired. So before the registration period expires, the registrar must give notice to the registered proprietor, notification in the manner specified, that the particular registration is expiring, and the notification specifies the date of expiration, the payment of fees, and the circumstances under which the renewal of registration may be acquired. If a trademark is withdrawn from the register due to non-payment of the specified fee, the registrar may renew the registration within 6 months and 1 year after of the expiration of the last date of registration of the trademark, as mentioned in section 3 of the Act. Also, within section 27, it is stated that no infringement will lie concerning an unregistered trademark, but it recognizes that under the law relating to trademark, even if a registration is not done, it does provide a remedy to the person who has not registered the trademark. So here we have a claim for passing off, right? So essentially what this particular point means is that in case a person does not register a trademark, of course registration is good. If a person registers a trademark, they will be able to get the benefit of filing a claim for infringement. There is a conclusive evidence of the fact that the trademark actually belongs to the person who has filed the application, who is the trademark owner. But in case a person does not register, it doesn't mean that they do not have any other option. They do have an option, right? This option is always available. So in case a person does not register a trademark, there is a passing off claim that is also available to them. So there is a common law remedy of passing off, whereby they can also have a claim for passing off in case somebody tries to have a free ride over the goodwill that they have built. Right, so this is all about the domestic process of registration of trademark. Thank you.